May I come in, sir?
Yeah, please.
Good evening, sir. Good evening.
Have a seat.
Thank you.
So, Miss Rekha, please introduce yourself.
Sir, my name is Rekha Roy. I have done my graduation in law, that is BLLB, from Faculty of Law, Banaras Hindu University, and I graduated in the year 2022. Since then, I have been preparing for judicial services examination.
So, you are appearing in this interview for the first time?
Yes, sir. This is my first attempt.
Okay. So, what subject you like most?
Sir, I like Indian Evidence Act and Constitution the most.
Okay. Indian Constitution. Which provision of the Indian Constitution is most you like most?
Sir, I'm comfortable with every provision, sir.
No. Just which provision of the Constitution?
So Article 14.
Article 14. Why you prefer this Article 14?
Sir, because it talks about equality,
Okay.
which is the essence of our constitutionalism. So, and constitution, it is a basic structure of our constitution, and it is related to social issues, sir. And in society, there is major problems lies with the equality from the time immemorial. So I like this provision. It provides equality to everyone.
Can you tell me that what is the term equality? What do you mean by the term equality?
Equality, so Article 14 of the Indian Constitution talks about equality before law and equal protection of law. Equality before law is a negative concept. It provides that it is taken from Constitution of United Kingdoms. It states that states shall not provide privilege to any person and treat every person equally. However, equal protection of law is a positive concept. It says that every everyone is equal protection of law says that everyone is equally protected by the law, and everyone equally circumstanced are equal in front of the constitution, and unequally circumstanced people are equal in
Okay.
the eyes of law.
So I think this Article 14 is a generic law. What are the other provisions of the Constitution which implement this Article 14 in practice?
So Article 15, Article 16, Article 17, and Article 21, sir. Article 40, Article 42, Article 40, articles. So this is all the articles which I
So you
could
have taken
remember.
the name of Article 21 also regarding the equality. So
Yes.
how 21 is related with the concept of equality?
Sir, in the case of Maneka Gandhi versus Union of India, it is said that Article 14, Article 19, and Article 21 are mutually inclusive, sir. And right to life includes right to life, live with dignity, and dignity comes only when the equality is provided.
Okay, so Article 14, Article 21, all are talking about the rights.
Yes, sir.
So what do you think about that? What is right actually?
Right is something. Sorry, sir.
Means when you can say this is my right. Right means what?
Right is something which is provided.
Okay,
Which-
legally speaking, what is right?
So right means something over which I. Sorry, sir.
In one line, you can say that right means claimed right.
Claimed right.
Claimed right. Claimed right means right. Okay. For anything, if you can claim, that is the rights. What about the fundamental rights?
So fundamental rights are some basic rights which are provided under Part 3 of the Indian Constitution, which is inherent to the man being a man, and it is a modified version of human rights.
So, do you think that human rights and this fundamental right both are same?
So human rights is broader concept. However, fundamental rights only deal with the part 3 of the constitution. All the rights which are inscribed within part 3 of the constitutions are only fundamental.
So how
rights.
you can differentiate between these two?
So human rights are all those rights which are provided to human by them being a human, by virtue of them being a human. And fundamental rights provides for such rights which are like protected from interference by the state, sir. And human rights are basic rights which.
Okay, so we were discussing that right means claimed right.
Yes, sir.
So do you think that human rights are also claimed right?
No, sir, human rights are not claimed rights, sir,
Okay,
in my opinion.
okay.
Yes.
So there is one act, specific act on this point, on the point of human rights. That includes human right means the rights which are written in our constitution, particularly the fundamental rights.
Okay, sir.
Okay, so fundamental rights are human rights.
So fundamental right is a part of human rights, but human right is broader in
So why you are saying that it is broader than fundamental rights?
Sir, because human rights are such rights which cannot be infringed by anyone. However, fundamental rights are only protected from intervention by the state, and some are also from private persons.
Suppose any rights which are recognized internationally as a human right.
Yes, sir.
But in India, we don't have any provision to protect that rights. So even you will say that it is a human right.
Yes, sir.
Any rights which is internationally recognized as a human right.
So human rights are universal, sir.
Okay.
And however, fundamental rights depends upon the constitution and law of the land of the country.
Okay. One knowledge-based question.
Yes.
That under which provision of the constitution the name of the constitution is written?
Sir, Article 393 of the Indian Constitution.
Okay. So what is difference between fundamental rights and the directive principles?
So fundamental rights are enforceable in court of the law. However, directive principles of state policies are only guiding principles which guides the legislature or executive to in administration, and so and it is not enforceable in the court of the law.
Okay. Last question from my side.
Yes, sir.
Tell one two rights which were earlier written in our directive principles, but now they become as a fundamental right.
So right to education, sir, Article 21A, which was added by 85th Amendment Act 2002, sir, and sir, it was made fundamental rights.
We have any legislation specific for this purpose?
Sir, I can't recall
Right
it
to education.
Sir, there is a legislation, but I'm unable to recall the name.
Okay, so right to education as a fundamental right is available to whom?
So, to children between 6 to 14 years of age.
So it means any person who is about 3 to 4 years. So he don't have this fundamental right.
So a person who is 3 to 4 years old is considered as like infant, sir, and basically a child from 6 to 14 years are such age of a person in which they are supposed to learn something or to learn the education, sir. So I think sir, I'm not able to clarify it clearly.
रेखा जी, आपने बताया कि आपका फेवरेट सब्जेक्ट कॉन्स्टिट्यूशन है।
Yes, sir.
अच्छा
Sir, Indian Evidence Act and Constitution.
अच्छा, लॉ क्या है ये बताइए।
Law is something. Law is a sanction made by. Law is a sanction. Law is a set of rules and sorry, sir. Law is a set of rules and regulations sanctioned by the government and the legislature of a state, sir.
आपने राइट ऑफ प्राइवेट डिफेंस पढ़ा होगा।
Yes, sir.
तो राइट ऑफ प्राइवेट डिफेंस में बताइए कि प्रॉपर्टी के अगेंस्ट जो राइट ऑफ प्राइवेट डिफेंस होता है कौन कौन से ऑफेंस में?
Sir, right to private defense against property is against, like, sir, theft of the property. If theft is being done, house trespass is there. If criminal trespass is there, sir, mischief is there. If mischief is there, and sir, if someone is committing mischief by fire, then also, sir, uh,
अच्छा, ठीक है।
private defense is available.
अगर किसी पर्सन के अगेंस्ट एक्सटॉर्शन किया जा रहा है
Yes, sir.
तो उसको राइट ऑफ प्राइवेट डिफेंस किस एक्सटेंट तक वो यूज कर सकता है?
Sir, in extortion, right of private defense cannot exceed to causing death of the person. However, it can cause hurt. He can cause hurt, simple hurt to that person, sir. I think.
ठीक है, आप हमें ये बताएं, अगर एक पर्सन है वो एलिबाई का तर्क लेना चाहता है तो एविडेंस एक्ट की, इंडियन एविडेंस एक्ट 1872 का वो कौन सा सेक्शन है जिसके तहत वो?
So Section 11 of the Indian Evidence Act talks about plea of alibi, sir.
सेक्शन 11 प्ली ऑफ एलिबाई को
Relevant बताता है, yes.
हम ये कह रहे हैं कि अगर वो डिफेंस लेना चाहता है
Yes, sir.
एलिबाई का तो वो कौन सा सेक्शन है जिसके तहत वो उसका डिफेंस ले सकता है?
Sir, I am unable to recall it right now.
लीडिंग क्वेश्चन बता दीजिए कि लीडिंग क्वेश्चन क्या है?
Leading questions are leading question has been dealt under Section 141 of the Indian Evidence Act. It says that any such question which suggests inferences as to its answer are leading questions, sir. And generally it is asked during cross-examination and with the permission of the court during examination in chief.
कोई पर्सन अपने ही विटनेस से क्या वो क्वेश्चन पूछ सकता है? लीडिंग क्वेश्चन की जो हम लोग बात कर रहे हैं, पूछ सकता
Yes,
है?
sir. If the witness turns hostile under Section 154 of the Indian Evidence Act, a party can ask question from their own witness, sir.
अच्छा, मतलब हॉस्टाइल विटनेस की डेफिनेशन कहाँ बता रही हैं?
Section 154, sir.
हॉस्टाइल विटनेस की डेफिनेशन है।
Yes, sir. So definition is not there, but sir, hostile witness is not mentioned over there, but it can be inferred from the text that hostile, that particular section is talking about hostile witness.
ठीक, मिस्टेक ऑफ लॉ,
Yes, sir.
एक्सक्यूज नहीं?
No, sir.
मिस्टेक ऑफ फैक्ट एक्सक्यूज।
Yes, sir.
आप बताइए मिस्टेक ऑफ फैक्ट क्या है?
Mistake of fact is mistake as to certain material propositions, sir, which form part of any offense, or mistake as to, sir, this is all, sir. I am unable to.
कोई एग्जाम्पल बता दीजिए जो आपके इंडियन पिनल कोड या बीएनएस में ना हो, हमको समझा दीजिए मिस्टेक ऑफ फैक्ट।
Sir, in contract law, if we talk, if two persons are entering into a contract and for the sale of a horse, and the horse is of unsound mind, but this is not known to both the parties, and both the parties are under the inference that the horse is of sound mind. So, sir, this will be considered as mistake of fact, sir.
अच्छा, एक मैगजीन हम लोग पढ़ते हैं, एक्टस मीन वीटू फैक्टस इज नॉन मेन सेक्टस, कौन सा सेक्शन से रिलेटेड है और क्या है इसका मतलब?
Sorry, sir, I don't remember.
अच्छा, मान लीजिए मैं आपको थ्रेट करता हूं कि मैं आपका घर जला दूंगा।
Yes, sir.
नहीं तो आप किसी का मर्डर कर देंगे।
Yes, sir.
और आपने मर्डर कर दिया।
Yes, sir.
ऑफेंस हुआ कि नहीं?
Sir, offense has been committed, sir.
अच्छा, क्यों? अभी जो
Sir,
मैगजीन मैंने बताई उसका मतलब यही होता है कि मेरी इच्छा के विरुद्ध किया गया कार्य मेरा नहीं
मेरा
है।
कार्य नहीं है। Yes, sir. This is done. This has been dealt under Section 94 of Indian Penal Code, sir. It says that except murder, if any offense has been committed by the person under the threat, then it will be not counted as an offense, sir. And it will be amount to, so the accused can take general defense, sir.
अच्छा, मान लीजिए इसको थोड़ा चेंज करते हैं। मान लीजिए हमने ये कहा कि कल मैं आपका घर जला दूंगा,
Yes, sir.
नहीं तो आप इनको चोट पहुंचा दीजिए।
Yes, sir.
क्या आपने चोट पहुंचा दी, ये ऑफेंस हुआ कि नहीं?
सर नहीं हुआ, क्योंकि सर वहाँ उसके पास अथॉरिटीज के पास रिकॉर्ड्स करने का टाइम है, तो वो उस टाइम पे वो ऑफेंस नहीं कमिट होगा।
उस टाइम पे तो ऑफेंस
कमिट होगा, सॉरी सर। यस, इट्स टाइम टू रिकॉर्ड्स टू डू।
एविडेंस आपने फेवरेट बताया था।
यस सर।
चलिए एविडेंस से हटा के सवाल पूछते हैं आपसे।
यस सर।
कंस्ट्रक्टिव लायबिलिटी और ज्वाइंट लायबिलिटी में कोई डिफरेंस है कि सेम है?
सर generally sir, joint and constructive liabilities are read together, sir. Joint liability lies when the person in furtherance of common intention, group of person has committed some offense, then they have joint as well as constructive liabilities, sir.
मतलब जहां जहां कंस्ट्रक्टिव लायबिलिटी होगी वहां ज्वाइंट, और जहां ज्वाइंट लायबिलिटी होगी वहां कंस्ट्रक्टिव?
No sir, constructive liability can be there in case of sir, in furtherance of like, sir I'm sorry, I'm unable to recall it.
एक क्वेश्चन और जवाब दीजिए।
Yes sir.
किस सब्जेक्ट से पूछिए, बताइए।
सर कोई भी पूछ।
किसी भी से।
यस।
एब्सोल्यूट लायबिलिटी का रूल क्या है?
Absolute liabilities, it's such a kind of liabilities where a person is liable in any case, anyhow, even though no mens rea is present, sir, and there is no exception to it, sir. MC Mehta versus Union of India, in case of MC Mehta versus Union of India case, absolute liability concept has been introduced in
आपने बताया मेंस रिया नहीं होगा तब भी लायबिलिटी हो जाएगी, एब्सोल्यूट लायबिलिटी।
यस सर।
सिविल मामला? सर
इन क्रिमिनल मामलों में मैंने बोला।
तो क्रिमिनल मामलों में एब्सोल्यूट लायबिलिटी का रूल कहाँ है? चलिए क्रिमिनल मामलों में स्ट्रिक्ट लायबिलिटी का रूल हम पूछ लेते हैं आपसे। क्या है ये स्ट्रिक्ट लायबिलिटी का रूल?
स्ट्रिक्ट लायबिलिटी is such kind of liability where even though person has no any particular intention to commit the crimes, even then that person is held liable for that offenses.
कोई एग्जांपल?
So bigamy, so contempt of court, kidnapping is there, sir, marrying having sexual intercourse with a woman less than 18 years of age, or even though sexual intercourse is done with her consent. So these all are the examples which I can remember, right?
एलिमेंट्स ऑफ क्राइम आपने पढ़ा होगा।
yes,
जिसमें 4 एलिमेंट पढ़ते हैं,
yes,
ह्यूमन बीइंग, मेंस रिया, एक्टस रिया और इंजरी।
yes.
तो क्या कहीं इंजरी हो ही नहीं तब भी ऑफेंस हो सकता है क्या?
Yes sir, at some places it can be like under section 126 of Indian Penal Code, mere preparation to commit any offense is punishable, sir, under section 127 also, sir.
और कोई एग्जांपल?
Sir, right now I could only remember these 2 examples.
अटेम्प्ट में इंजरी होती है? जरूरी
sir,
है?
in attempt there no injury, sir, but
इनकोएट ऑफेंस कौन सा ऑफेंस होता है?
Inchoate offenses are those offenses which are not complete, sir, which are not completed, and the objective for which the offense has been it's committed has not been completed, sir. I think inchoate offenses includes attempt to commit any offense, like and sir, abatement also is inchoate offense.
ठीक, गुड।
Rekha,
yes sir.
can you tell me about ownership?
Ownership is the absolute interest of a person in any property, sir.
What do you mean by absolute?
Sir, that the person has all the rights to dispose of such properties, sir, and take care of such property.
Have a cash money.
Yes,
It's my own,
yes, sir.
and I just want to burn it outside. So whether it is my right, ownership. We have ownership, and we have all the rights.
Yes,
So just want to burn it.
yes, sir.
So can I do?
So you are not supposed to do that, sir, because money is like something which comes from, sir, I'm not able to explain it, but you can't do so, sir.
Raj Judicial Classes is situated, at the very post area.
Yes.
Suppose I just want to burn it. It's my own. I just want to burn it. Just get it into fire. So what I can do?
So you can do it, sir. If you want to burn your property, you can do it, but money, I think. So money is something which is, sir, I am unable to explain it.
Have you any idea about garnishee?
Yes, sir, garnish.
What is it?
So garnishee is the debtor of judgment debtor. So garnishee is the person who is a debtor of judgment debtor, and uh, when the party against, when the decree holders apply to the court that certain in money decree, sir, that certain amount of money is due from that judgment debtor, and there is his creditor, then the court can ask such person to not to pay the amount due to the judgment debtor, but to the like decree holder, sir, and such person is known as garnishee, sir.
What do you understand by attachment?
Attachment is generally made by court. It is made during execution. It might be attached before like a decree, and attachment may be made before a decree or after decree, sir. But its execution takes place,
When it can be before decree?
sir. Sir, if there is possibility that the person is about to dispose of his property in disadvantage of the person, the plaintiff, then in that case, attachment can be made before like decree, sir, passing of the decree.
In case of maintenance, suppose a decree has been passed and you are going to the decree holder is going to execute it through attachment. How much your salary, suppose a salaried person, against this decree has been passed against the salaried person. Suppose how much salary can be attached in case of maintenance?
Sir, 1/3 of the salary can't be attached. Remaining can be attached, sir, as per Section 6 of in Transfer of Property Act. So Section 60 of Code of Civil Procedure, sir. Sorry.
So, have you any idea about suit of civil nature?
Yes, sir.
Can you give me some example of its exceptions also?
Yes, sir.
Can you?
Yes, sir. Exceptions to suit of civil nature can such questions which is purely political or purely religious, sir. Such questions are and any suit is filed, and such suits are not suits of civil nature, sir. Suits related to uh, suits related to like such.
Have you studied
Yes, sir.
about Section 2D of Human Rights Act?
No, sir, I haven't studied human rights.
Sir, have asked you question
Yes,
that how the fundamental right is different from the human right.
Yes, sir.
And actually, the definition clears it.
Okay, sir.
That's why I have asked you question that section, whether you have gone through the section 2D of Human Rights Act.
Sir, I'll definitely read about it, but as per now, I haven't read it.
So, where in which provision women should be respected, that is given in the Constitution.
Sir, it is given under Article 51A, sir. 51A(e), sir. Subclause E, sir. It is given that women should be respected, sir.
Okay. So, have you any idea about uh, community punishment?
Yes, sir.
So, tell me about.
So, community services is the new form of punishment which has been uh, uh, prescribed under Bharatiya Nyaya Sanhita, sir, and it is defined. It is explained under Section 23 of Bharatiya Nagrik Suraksha Sanhita. It says that community services are services for the benefit of the public without any remuneration paid to such persons. And
Suppose first appeal has been made.
yes, sir.
In the civil case,
Yes, sir.
first appeal has been made, and that appeal has been made from the district court. The first appeal, where the first appeal lies,
Sir,
that is lies in
High Court,
Court. And where the second appeal lies?
So, second appeal could lie to High Court also, sir, and then second appeal will lie to Supreme Court, sir. So, in cases where in High Court, if the hearing has been done by appeal has been heard by a single judge bench, then such a decision of the judge can be appealed in the same court for larger bench, can be appealed to larger.
I'm just talking about the second appeal.
So second appeal will generally lie to High Court, sir. As far as I remember, sir, as per Section 100 of Code of Civil Procedure, second.
Having any idea about notional partition?
No, sir.
Have you ever heard about?
No, sir. I haven't.
What is co-parcenary?
Co-parcenary is the right. Co-parcenary is a right of the person. Person of Hindu undivided family, and it is a right by birth to take interest in the joint Hindu family properties. Sir. Co-parcenary is basically related to Hindu personal law, and it has been included under Hindu Succession Act also, sir. Under Section 6.
Okay, Rekha, thank you.
Thank you, sir.
Okay, Rekha, I think 1-2 questions more from this in the entire committee. I wanted to know that what are the quality you possess that is different from others?
Sir, I'm a very emotional person, sir, and my emotion is my strength, and I can't see injustice happening in front of me, and I stood for it. And sir, my honesty, I'm very an honest person, and I'm a very disciplined, punctual, and I have a good understanding of societal nuances, and so good understanding of law. So I think I am suited for this position.
Okay. If you will be selected by this committee, so what you will do for the justice or for the society?
Sir, for the society, I could do that. I will work in a time-bound manner, sir. I will give priority to thoroughness as well as timelines, sir, and I will adhere to the principles which has been provided under, sir, administrative law, like principle of natural justice. I will adhere by such principles and evidences produced before me, and I will be impartial, sir.
Okay, thank you, Rekha.
Thank you, sir.
Best of luck.
Thank you, sir.